हेलो एवरीवन। वेलकम टू लीगल टॉक्स विद सीएस यातिन। तो चलिए आज बात करते हैं एडीएम जबलपुर वर्सेस शिवकांत शुक्ला ऑफ 1976, द हैबियस कॉर्पस केस, द डार्केस्ट चैप्टर इन इंडियन कॉन्स्टिट्यूशनल हिस्ट्री। Imagine this. One midnight, the police arrive at your house. They arrest you. No explanation, no charges, no trial. Your family runs to court asking for justice. And the government says courts cannot help you. Even your right to life and liberty is suspended. Can this happen in a democracy like India? Shockingly, yes. And India has witnessed exactly this. Today, we discuss one of the most controversial judgments in Indian constitutional history, ADM Jabalpur versus Shivkant Shukla, which is famously known as Habeas Corpus Case. Today's case is not merely a legal judgment, it is a warning. A warning about what happens when the constitutional institutions fail to protect liberty. This is famous ADM Jabalpur case decided during the emergency period. Every law student must understand this case because it teaches constitutional accountability, judicial courage, misuse of executive power, and the true meaning of liberty. To understand this case, we must first understand the political atmosphere. This year was 1975. India was going through one of the most turbulent political periods. Prime Minister Indira Gandhi's election was challenged by Raj Narayan. The Allahabad High Court found her guilty of electoral malpractices and set aside her election. This created a major political crisis. On 25th June 1975, emergency was declared under Article 352. At that time, the ground was internal disturbance. This changed the entire constitutional environment. During emergency, opposition's leaders were arrested, political activists were detained, newspapers were censored, public criticism was suppressed, civil liberties were severely restricted. Thousands of people were arrested under MISA, that is Maintenance of Internal Security Act. This law allowed preventive detention. What is preventive detention? Preventive detention means you are detained not for what you have done, but for what the government thinks you may do. Let's take a simple example. Suppose the government believes you may organize protest. Without waiting for any actual act, it detains you. That is called as preventive detention. Families were detained. Families of detained persons approached high courts. They filed habeas corpus petitions in the courts. Habeas corpus literally means produce the body. This is constitutional remedy against illegal detention. The court asked the government, bring the detained person before us and justify the detention. Several high court several high courts gave relief to detainees. Court said even during emergency detention must follow law. Executive power cannot be completely unchecked. The government challenged these decisions before the Honorable Supreme Court. The constitutional question was shocking. If Article 21 is suspended during emergency, can a citizen still approach court to challenge illegal detention? The government made an extremely extreme argument. It said presidential order suspended right to enforce Article 21. Therefore, no person can approach court. Even if detention is illegal, courts cannot interfere. This argument effectively meant if government illegally arrests you, you have no remedy available. Petitioners argued liberty is not merely constitutional gift. Even without Article 21, the state cannot arbitrarily imprison people. Rule of law must survive. This matter was heard by Constitution bench of 5 judges. The judges were Chief Justice A.N. Bray, Justice Beg, Justice Chandrachud, Justice Bhagwati, and Justice H.R. Khanna. By majority 4:1, the Supreme Court ruled in favor of government. The majority held during emergency right to move court for enforcement of liberty is suspended. Habeas corpus petitions are not maintainable. Courts cannot examine detention legality. This means even if arrest was malicious, detention was illegal, executive acted without authority, the citizen had practically no remedy available. Why this judgment shocked the nation? Because democracy expects courts to protect liberty. Instead, the judiciary sided with executive power. The Great Dissent by Justice H.R. Khanna. This is where constitutional history changed. Justice H.R. Khanna stood alone, one against four, but his dissent became immortal. He said, the right to life and liberty is not created by Article 21 alone. It exists even independent of constitutional text. The government cannot deprive liberty without legal authority. Justice Khanna believed rule of law survives even in crisis. Emergency does not create dictatorship. Because he knew the consequences, it was widely believed his dissent cost him the Chief Justiceship. Sometimes one dissent becomes greater than majority history. This case is criticized because judiciary failed liberty, executive became almost absolute, constitutional remedies collapse, and this case is therefore called as a darkest chapter in the constitutional history. After emergency ended, India corrected this mistake. This amendment, that is 44 constitutional amendment, ensured articles 20 and 21 cannot be suspended even during emergency. Subsequent courts strongly criticized ADM Jabalpur, especially in case Puttaswamy privacy case 2017. The Supreme Court effectively declared ADM Jabalpur wrongly decided. Think of democracy like a building. Legislature makes laws, executive enforces them, judiciary protects citizens. In ADM Jabalpur, the protective wall collapsed. This case teaches rights are meaningful only when courts are willing to enforce them. So, in conclusion, ADM Jabalpur remains a painful reminder that constitutional text alone is not enough. Democracy also depends on judicial courage. If you found this explanation useful, do like, share, and subscribe to Legal Talks with CS Yatin. We will continue with such kind of discussion about the constitutional case laws. Happy learning. Till then, goodbye.